All right, this is Jonathan Franklin Wadley. Mr. Wadley, your parents are here and they've been waiting patiently. This was set for a probation violation hearing today. The file number is 24120FY. You were charged originally with assault with intent to commit great bodily harm by strangulation. The matter was reduced down to a domestic violence first offense, and you were placed on probation. Your probation officer was Autumn Kiefer, and she is here today. And she has filed a petition alleging that you violated your probation. I read this to you when I saw you last week, but let me repeat it. You were placed on probation in May of 2024 for 24 months for domestic violence. The allegation is that you failed to abstain from the use of alcohol or drugs or submit to a test upon demand. A probation violation arraignment was set for October 9th, 2024 at 9:30, and you never showed up. So there's been a bench warrant out for your arrest since October of 2024. So additional allegation is that you failed to report or otherwise comply with the terms of your probation. So I arraigned you on July 1st, which was last Tuesday. And I wanted to do this as soon as I could. I set it for today, Wednesday, July 9th, because your lawyer, Mr. John Bush, was scheduled to be here on another case, Travis Andrews. I thought, well, good. His lawyer will be here. We'll do it at that time. In the meantime, so we sent a notice to Mr. Bush that day, July 1st. And I've confirmed that it went there. But John's secretary didn't seem to have this on the calendar for today. In the other case, Travis Andrews, Mr. Bush requested an adjournment because he was going to be out of town on business meeting with the client. So the prosecutor agreed, and that case has been adjourned until August. That defendant is in a treatment facility. He's not in jail, and that case can wait a month while we see how he's doing. In your case, you're in jail. You've been AWOL since last September. You just happened to get picked up last week. They came to your house. And as of now, you have $9 days of jail credit.
They consider it 10, Your Honor.
What?
They're considering it 10. I looked before I came up.
10 days of credit. Your probation officer, let's go back to the original judgment. Now, joining us, because Mr. Bush couldn't be here on very short notice, is Mr. Keith Stickley. He's the Chief Public Defender. And I appreciate his help here. This started as a strangulation. Your wife alleged that you strangled her. The prosecutor dismissed that charge and the charge of second offense domestic violence for a plea to first offense. In my sentence, I let you out of jail. There had also been a mental health petition, and you went into treatment a little bit at Pines. I gave you 62 days, credit 2 days, and I deferred 60 of the days and let you out of jail, hanging 60 days over your head. So you have done a very poor job on this probation, and your probation officer, Ms. Kiefer, recommends I simply revoke your probation and give you the 60 days jail that I had deferred minus 10 days of jail that you have done. So you would get 50 more days minus good time, which would be something like about 42 days or something. I'm not exactly clear. So I had hoped that you would have an opportunity to talk to Mr. Bush. When I saw you on the 1st, I thought you were just going to acknowledge that you haven't reported for 10 months and call it good. But I wanted to have an opportunity for you to talk to a lawyer. So here's our options. If you admit that you failed to report and fell off the map, I'm going to revoke your probation and give you 62 days, credit 52 days. And I'll be off your back when you get out of jail. If you wish to have a hearing, Ms. Kiefer can testify that she hasn't heard from you since last September till you got arrested. Mr. Stickley could represent you at that hearing. Mr. Wadley, I also can put you in a room where you can talk privately with Mr. Stickley if you'd like to do that. Frankly, the other thing I wanted to do, you were still pretty twitchy. I wanted to give you some clean time. And so you've been in jail now for 10 days, and I think you're probably clear-headed and thinking clearly. So what would you like to do here this afternoon?
We could talk with the attorney.
All right, could you take him out to the, could you guys open the Zoom room? I know it's a security issue to take him out in the hall, but I think we'll be all right. Mr. Stickley was unable to actually be here. All right, we're going to take you into the Zoom room and you can talk privately with Mr. Stickley, and that's probably the wisest choice. All right. Why don't we wait a minute till Laura
So you
opens
can
it?
do that, or I can log into my Zoom and Mr. Stickley can log into mine. They can take my laptop, since I know it's a security issue to have them in the home.
Yeah, why don't you go ahead? Well, then she'll be there. So
No, I'm
let's-
not gonna be there.
No,
Always talking about me.
Michelle. So let's put him in this, go ahead, put him in the Zoom room.
I'm happy to do whatever.
Yeah, this was set for 1. It's now 2:15. We had to line up counsel, which I appreciate is coming on short notice, and we had to wait for the magistrate to do the regularly scheduled arraignments. Of course, then there was a holdup from the jail, and there's always a hard time getting everybody in the right place at the right time.
Keith, were you done talking to him privately, or do you need to?
I am, yeah. I don't know what else I can offer at this point.
Why don't you bring him back in the courtroom?
Yes, sir. All right, Mr. Waddle.
All right, thank you to our bailiff staff. That's not ideal, but we did make him available to talk with counsel. So, Mr. Wadley, we're kind of back where we were. The allegation originally was that you failed to test, but probably the more straightforward allegation is you failed to report to your probation officer for the last 10 months or so till you got arrested. I told you what I was going to do if you entered a plea to the charge, and what we could do if you didn't wish to do that. So what's your preference here?
I don't understand here. I'm not getting.
Your Honor, if I could,
All right,
Your Honor, if I could interject, Your Honor. Your Honor,
Yeah.
I tried to very clearly and concisely explain what his options were. And I don't know what detail of appropriateness it would be to go in, but I'm not sure he's understanding what I'm saying, or he's not
All right,
willing
well-
to communicate rationally as far as
All right, well-
the procedure and what's happening.
Well, let's see where we are here.
Okay.
Mr. Wadley, Mr. Bush I don't know what happened to the notice. You don't have much of a defense. You,
I actually got a bigger defense than.
all right, well, you quit showing up. We haven't seen you in 10 months.
I know, I'm aware of that. I meant no disrespect. I'm working with, like I said, a federal detective over this. I was rage baited and drugged. Like they had me, I had an ex call the hospital and have me locked in a psychiatric ward.
And I knew
Yes,
you
sir.
were in a psychiatric hospital for
Okay,
a while.
now, my
Rage bait.
mother-in-law passed away. Now, my ex called the hospital and said that my mother-in-law feared for her safety. Now, my mother-in-law was deceased. I didn't even get to be with my wife while she went through that because of an ex locking me in the psychiatric hospital.
Now, you were in the psychiatric hospital from when to when?
I can't remember the dates.
Yeah, it was last fall.
And I'm not sure what the dates were, but I know that this has all been a series of stages to just like screw me out of my life over an ex. I mean, they've dumped revenge porn. They've had a whole community come after me and blackmail me. I've submitted several reports to the state police that have done nothing to do an investigation. I was beaten, raped. They never gave me a rape kit.
And where was all this?
This all happened between Branch County from the time I got arrested and the time that I got released. And this has been going on.
All right,
And
so
I can't get
as
any
of
kind of,
last
and-
June, but when you got arrested here, June 30th,
and I've got several
all right,
letters that.
you
when I
said
was
they
in-
came to your mother's house,
You know,
and arrested you on this warrant.
Yeah.
Okay,
like it's not anybody's real fault, but I've been trying to work with the police and they won't even file any kind of claim.
Now,
They
I
won't do
don't- there's
investigation.
been an open warrant for your arrest since last October.
So,
Any police officer that would have communicated with
That's
you
right.
between then and now probably should have taken you into custody.
okay, now I have several emails where I've sent to the state police with my address, with me. I've called
All
and
right.
made reports and they've done nothing to investigate this. Like,
Well, okay, I don't know about that. If you wish to have a hearing, I guess we can set it when Mr. Bush gets back, but I'm not gonna let you out. You went off the grid for months.
even though
And it's a
tether-
serious assaultive offense that was reduced to a 193-day misdemeanor.
Okay.
I gave you 2 days and let you out, and you repaid me by poking me in the eye with a sharp stick.
So I'll plead
I'm
guilty.
offering to just give you the time served, a time originally ordered, rather than any additional sanction. The only allegation that you would have to admit to was that you failed to report from last October
I'll take guilty.
All right, well, let me ask this. Did I threaten you into doing this?
No, just no officer will do their job. So
All right,
yes.
now, I can't speak to that. Your mother said when you were in the break room, said he doesn't do probation very
I
well.
completed 2 years felony probation, no violations. I completed 2 years parole, no violations. I
All right.
can't do nothing about my kids and everybody drugging me and locking me away, dude.
And you told me that
Excuse me,
you,
sir.
you're all right, there's Kleenexes there, that you recently found out you had kids. And you
Yeah.
didn't know that you didn't have any
My
children.
biological kids, I didn't know.
And
have
that
stepkids.
certainly would be upsetting. But none of that stuff, it certainly is concerning, is a defense to the fact that you just quit showing up for probation.
I feel like it was all stacked against me. I feel like this courtroom is like I'm being sold.
Well, I'm willing to give you a hearing, but as I said, it isn't going to be very hard to establish the facts. Now, I didn't know how much was methamphetamine and how much was mental illness, and where one line starts and the other one stops.
I need witness protection after this.
Um,
That's what's gonna happen.
all right,
But I'll plead guilty. I'll take the 60 days.
all right,
Get this
Keith,
over with.
I'm reluctant to go down the competency evaluation path. All right, Mr. Wadley, let me make sure we're on the same wavelength. Did you understand what I'm going to do if you acknowledge you failed to report to your probation officer?
I do, Your Honor.
I'm gonna revoke your probation. I'm gonna suspend all the fines and costs you owe. When you get out of jail, I'm gonna be off your back. Understand?
Yes, sir.
Do you understand? You have a right to have a hearing on this if you wish, where we could take testimony. which case I could give you up to 93 days in jail. And do you acknowledge that you failed to report to your probation officer
Shouldn't even,
from October till you got arrested on June 30th? Do you admit that?
yes, Your Honor.
All right. John, when's the last time you were connected with Pivotal or anybody from Community Mental Health?
I quit doing that since they were trying to take a power of attorney and take off with my life.
I'm gonna ask Pivotal to come see you at the jail. You need some mental health help
It's not
here.
mental health, it's people causing the mental health.
All right, well, stress can cause it.
Well, the feds will straighten us out when I get done with this.
All right, very good. I'm gonna order 62 days credit, 52 days, leaving 50 days to serve.
No, Your Honor, that's not right. 60
credit.
days credit. 10,
Credit 12.
okay, not 52.
Yeah, that's backwards. Leaving 50 days to serve. He had 2 up front and the 10 that he just did. I had it exactly backwards. 62 days credit 12, leaving 50 days to serve. And your probation is revoked. The remainder of your fine and costs are just waived. And you don't have to talk to him, but I'm gonna ask CMH liaison or Pivotal liaison to check in with you. They do have a couple of trustee slots inside. Sentenced defendants are eligible for trustee. They make you a kitchen trustee or something. You could get out even sooner. They don't have any outdoor trustees anymore, like the garage or the lawn or any of that stuff. All right, Mr. Wadley, as I said, I'm off your back. I don't wish you any ill.
And I'm sorry that you guys got drugged through this. I got politically assaulted and I know it's not your guys' fault.
All right, you're good to go and good luck.
I love you too.
Sorry I couldn't be of more assistance, Your Honor.
Well, thank you, Keith. I don't know there was a good answer to that. I think there's some,
If he wants to talk to you, then.
yes?
Am I free to go, Your Honor?
Yes.
Thank you.
This, in his mind, he thinks he has 3 wives, 9 kids.
Actually.
Yes,
He actually believes this.
yes, he's got some.
He's really got some mental problems.
He
that gotta
does.
be addressed.
It's not.
I think he understands what just happened, but he's got some delusional thinking, and I'm gonna ask Community Mental Health to go talk to him.
He really believes, in his own mind, he believes this is true, because I think a long time ago, he done so many drugs, and I caught him one time trying to electrocute his brain, standing in the water.
Was that Ashley Miller?
Yes, please. Yes. Yeah.
I
Okay.
did like Gabby Miller coming in there and giving a little post hearing analysis. That was
We
fun.
are on the record in 2025 TR 728, State of Kansas versus Ashley Raynell Miller. Jared Regier for the state. The defendant, Ashley Miller, appears in person and pro se. Ms. Miller, you are charged with driving in violation of your restrictions on your license. Apparently driving without eyeglasses. This carries a fine of up to $200. A 30-day driver's license suspension is mandatory. You do have the right to plead not guilty and set this for trial. You can plead guilty and proceed with sentencing today. You can plead no contest, neither admitting nor denying the charge, but you would still most likely be found guilty and proceed with sentencing today. Depending on your history, if any, you might, you're not going to be eligible, I don't think, for diversion. I was going to say you might be eligible for diversion, but it looks like you may have had a diversion for,
A while ago.
well, yeah, 23 for expired tag and 19 for speeding, you were found guilty. So I don't think diversion is going to be an option for you, but again, I don't decide that. While you're pondering those things though, Miss Miller, I want to comment that on April 15th of 2025, you called in to the clerk's office. You'd called in previously. And on that date, you spoke to one of the most friendly, considerate clerks. We have a lot of them, but the one you spoke to is exceptionally good at helping people. And you proceeded to curse at her multiple times, repeatedly saying that the quote, the officer had written this stupid, paraphrasing, effing, back to quote, ticket, just so he could make money from you and make a stupid quota, end quote. You repeatedly asked what your costs were. The clerk informed you that there would be court costs most likely added to your case, depending on what you were cited for, but without seeing the ticket, she could not inform you of the other fines and fees. You told her that this was stupid. It was stupid that it had gotten here in the first place. You told her you were cited for something stupid because you've never worn your glasses and you didn't know why it was ever marked on your license anyway. You asked if you had to appear in court for this stupid ticket. The clerk told you that she could check by looking at the bottom, or that you could check by looking at the bottom of your ticket, that if a specific box was marked, then you would have to appear for court on the date and time indicated. You again said it was completely stupid that you had to appear for court and that you couldn't believe you had to pay court costs and everything, even though you thought this case was dismissed or should be dismissed. The clerk went on to try to tell you that if it was dismissed, you may not have to pay any fines or fees. And then you hung up on the clerk before she was able to get a response.
I'm not sure as to what this has to do with the clerk, considering we're in court right now. So I'm confused.
It has everything to do with the clerk because it has a lack of respect
Great
for the
argument.
court. It is the clerk of the district court. So when you disrespect the clerk, you're disrespecting the court.
So if she's disrespectful towards me, that's invalid is basically also what you're saying though.
Well, I'm saying the particular clerk that you encountered is, to the best of my knowledge and belief, extremely courteous, patient, and polite.
And generally when I had called, I was trying to be patient, courteous, and polite and treat her with kindness and respect, but she was extremely short with me. Also, I'm autistic. This is about facts, and I don't understand why we also have to bring feelings into it. It's inappropriate for me to bring feelings into it, so that's wrong of me, and I own that, but also I don't want them bringing their feelings into it either. This is about
who do you think you are? Who do you think you are?
facts. I'm trying to get the factual information so I can do what's needed of me to be a law-abiding citizen, so.
This has nothing to do with feelings. This has to do with respect, which is a sign or symbol that you appreciate the role of the court, that you respect the law, and so far you've not shown that. And that doesn't help you get very far. So I'm telling you that your tone even today is questionable. I don't accept the fact that autism just makes you rude.
I never said that. You said that.
Yes, I did, because that's what I conclude, that you're being rude.
I'm not trying to be rude at all.
All right, well, you are being rude. Now, Miss Miller, whether you think this charge is stupid, whether you think you need eyeglasses, apparently someone tested you at some point in time and said you do. And that if you don't wear your eyeglasses when you're driving, that could be a risk to other motorists and pedestrians or even to you. But that is to be determined at a trial. Do you want a trial on this charge?
Well, considering I've recently gone and gotten a new driver's license and I passed the eye test, I guess I'm unsure. I didn't realize it would even get this far where we are going to have to go to trial over somebody marking it was wrong on it shouldn't have been marked because I passed every vision test. So I don't understand. I'm extremely confused so I guess we're going to have to go to trial.
All right, I will enter a not guilty plea. We will set this for bench trial. You must be back here for bench trial, August 27 at 1:30.
Your Honor,
Yes?
I apologize. It'll actually be September 17th. August 27th is full.
Thank you. We will set this for bench trial, September 17th at 1:30. And if you wish, you can ask the officer in cross-examination about his quota or whatever you wish. And this is not one that she has to get her picture and prints taken. I don't have to post a bond. Anything else, Mr. Regier?
No, Your Honor.
All right, anything else, Miss Miller? You do have the right to hire an attorney, but because the maximum sentence is 30 days and not 6 months or more, I'm not in a position to appoint an attorney. But you certainly can hire an attorney or you can continue to represent yourself. Anything else? All right, then you're excused at this time, Miss Miller. Thank you.
Next one I have is Jamie Cantu. Cantu starting with a C.
Thank you.
He's calling me on my name. He's verbally disrespecting me until the point I got fed up in June 19th. Come May 20th, he texted me at 7:54 in the morning, calling me a God D liar and all this. I'm like, it's only 7:54 in the morning. I pay my rent on the 20th. So they came over here verbally being too much, like verbally all this. She handed me that pink copy of the eviction, but I talked to her and I told her it's not a rental problem. It's us coming together to have respect. I never physically got in an altercation or disrespected with her, but her son is mostly like the problem. I have the text messages, I have the stuff they didn't fix in there. I have everything where it makes me say that I don't want to rent no more with them.
Okay, so as far as what they did or did not fix, that can be addressed in another set of court. If you want to turn around and sue them, you can sue them all day long. That's fine. But it has nothing to do with this court. This court is strictly rent. So give me 1 minute. Mike, what are you asking for right now?
The past due rent for the month of June is $900 plus possession.
So rent is $900 a month. You're asking for June, which is 1 month of 900. Okay, so, as far as Mickey Dixon goes, that's the one we have the lease with. We don't have a lease with you. Okay, for whatever reason, they didn't sign the lease. I can't force them to go back and sign a lease. Okay, you stayed there knowing that there wasn't a lease there. So
She did it.
I understand, but you also have to take some responsibility. You stayed there, you paid that rent, and there was no lease.
On the behalf of, I know my cousin Mickey Dixon didn't go through this with them.
Okay, but the only thing I have in writing is that Mickey signed a lease, not you. So unfortunately, Mickey's the one that's gonna stick with the repercussions of it. You don't have a lease. I can't bind you by anything because you're not binded by any contract. Okay, so I can't put any judgment on you. You don't own the house. You don't have any binding contract to that house. All I have is Mickey Dixon, okay, and all occupants, okay?
Okay, so.
So right now, the judgment's gonna go towards Mickey Dixon, and everybody's got 5 days to move out. That doesn't,
Moving on Thursday, I already have somewhere to go. It's just me letting you know they're not receiving no payments.
so judgment's gonna be for $900. And then since I gotta say, you've got 5 days to move out or appeal it. I do understand you've moved out already.
Yeah.
But the judgment is gonna go on Mickey Dixon.
And how would I know I won't receive no more verbal threats or, because I do have a police report out on. Mr.
Okay,
Mike.
now if you feel unsafe in any shape,
do.
way, or form, you can always call 911. That's all I can tell you. I can't physically tell him to stay away and him actually listen. I don't.
Because I'm just saying, tenants do have rights, you know what I'm saying? And as me being respectful, and he's telling me, calling me out my name, discriminating me, after this right here, I don't want no dealings with them. I'm moving Thursday. My apartment will be ready Thursday because I refuse to pay the rent. I had their money, but when it came
And
to
like I tell everybody, and you
Okay.
feel like your life's in
the
danger,
disrespect,
call 911.
I'm done with it. But after this, how I know he won't try to contact or reach out.
He knows not to come near you. He knows that you've got 5 days to
He
move out.
did threaten to say he didn't need the court to throw my shit out, in his words. But thank you.
Thank you, ma'am. We've got, yes, ma'am. Have a good one. Latanya Clark. Ma'am, that's enough.
We waited 12 minutes outside. They shall open the doors.
All right, Mike, go ahead and get it started. What is the monthly rent?
At 1,500. We're asking for 1,500 for the month of June in possession.
All right, Ms. Clark, first of all, do you agree that your monthly rent is 1,500?
Yep.
Second of all, do you agree that June has not been paid? Okay, and is there anything you can do or offer to become current?
Nope.
Judgment's gonna be in the amount of 1,500. You've got 5 days to move out or appeal it.
One more thing, it's just like the same lady, yeah, having threats from this man gonna throw our shit out. They actually served us with an eviction notice the day of our rent day, which we were gonna pay it, but for the last 2 months we've been with them, it's been nothing but threats. 3 days before the rent due, hey, y'all need to get out, you niggas need to get out, your black ass ain't over this, you can go back to.
All right, sir, all right, sir.
You know what I mean? Well, this is what I got on my message and what I got. I mean, he's threatening my kids and everything. At first he portrayed he was the sister, but now I know gratitude to him, it's no problem giving me a call.
All right, that's enough.
Thank you.
We've got Siller.
Goodell.
All right, go ahead, Mike. What's the monthly rent?
There's a balance due of 200 for the month, past few months. It's accrued. We're asking for 200 and possession.
But what's the monthly rent just for appeal?
1,450.
1,450?
Yeah, it's strictly when I have 200.
And I'm sorry, what'd you say?
200 is past due from the previous 3 months.
All right. Ms. Siller, first of all, do you agree that your base monthly rent is $1,450?
Yes.
Okay, and go ahead.
And no, all my last 3 months, all my rent is paid in current. Everything. I paid $1,550 this month. I paid $1,550 last month, and I paid $1,500 the month before. I was late 2 months of my rent because I've been on disability. I'm on FMLA.
Okay, so
I reached out to them, sent them my FMLA paperwork. He told me I'm a lying bitch. I shouldn't be arguing. I'm too sick, and I have proof. They have their rent in fucking full.
Okay,
Sorry, I'm sorry.
that is enough.
Sorry.
I am not gonna have no more cussing at all anymore. That is enough.
Sorry, Your Honor, but my rent is paid in full for all the months that they're saying there's a 200 balance. There's not.
All right, so, Ms. Siller, you did mention that you were late 2 months.
2 months,
Okay.
yes.
What 2 months were you late?
My rent is due on the 16th. So May's rent was late, and June's rent was late.
Okay.
They told me that I needed to pay $1,550 for May, $1,550 for June. I paid $1,550 in May. I paid $1,550 in June.
Okay, Ms. Latowski, can you go ahead? Can you go ahead and tell me where that $200 is coming from?
Previous months, she was, not those 2 months, but the previous 2 months when she moved in, she was 50 and 50 short and 100. But if you want, we can reset it for 1 week and we'll research the
Okay.
payment.
Can you let him finish?
I have proof.
Okay, that's enough.
We can reset it for 2 weeks and let us research the payment, and if it's.
Okay, Alyssa sent me this, and I have the wrong clip. I'm in the wrong spot of what she sent me, and it's just a zoo. I knew it was wrong because what she sent me is a long clip, and this is a bunch of them. This thing's out of control. I got here by accident, and it's hilarious. All right. I'm gonna start on another one she sent me, and I'm gonna start at the right spot. All I can say there is I was lucky. That call is so terrible. You can go at any point. You can just go in there at any point and just see ratchet crazy. All right, let's try this one here. Let's try this one.
You may, I may not be able to answer.
Is he getting out or?
He's still on a cash bond for his other matters, so he needs $2,000 cash to bail out.
And that's for the criminal matter.
That's
so-
the criminal matter.
That's all. I think there's no other 200, 2,000 plus 600 plus 300 plus.
No, the child support warrants have been quashed, so he doesn't have to pay or he has to pay his child support, but he doesn't have to pay the warrant to get out of jail for child support. He just has to pay the warrants in the criminal case.
Where is that? How do you go to it?
You go to the clerk. You can go talk to the clerk about that. All right. We will go on the record in the matter 02 FA 71. Oh, Rachel Erickson versus Kenneth Erickson. Appearances are Mr. Erickson appears in person without counsel. We have Stephanie Thomas Schmidt, Corporation Counsel, appearing in person. We're set today in this matter for a hearing. Mr. Erickson, I believe, motioned the court to be heard on a few issues. Briefly, Mr. Erickson, do you want to update the court? Tell me what you're looking at.
Yeah, I wrote you a letter.
I read it.
Okay. Yeah, well, you sent it to me back in, what was that, May 5th for, it was 10 days. And, well, when I got out, well, I was doing a job search for twice a week, whatever. Well, then they mailed me this. Child support did. Well, then they put out a warrant for me. So I sat another 20 days and they didn't find me in contempt. So
What are you asking?
well, I'm asking is that I said an extra 20 days for nothing. Why would they put a warrant out for my arrest for doing what you told me to do? And they didn't find me in contempt of it. They just made me sit in jail for another 20 days. I mean, what for?
Okay. Ms. Thomas Schmidt.
Your Honor, Mr. Erickson was found in contempt on March 5th. His sentence was amended to 30 days with 10 imposed and stayed, including 1 day of credit for time served. A warrant and commitment order was done on May 14th. due to non-compliance at that time. We had not received any work searches. We had not received any, I don't believe we'd received payments, but I'll have to double check where that was in the file. No payments, I'm being informed. So we did request the warrant to lift the stay for, I believe we requested the warrant to lift the stay for that 10 days, 10 of those days, and he did sit in jail for 90 or for 20 days, I apologize. But he did, upon his release from custody, begin supplying job search forms to us. At least one set of job applications. And so that's the history.
Is he in compliance right now?
We have a recent job search dated June 26th. He's due to supply another, but we're not seeking to incarcerate him anymore at this time. We're seeking to let him try to purge himself.
All right, so back on the purge conditions?
Yes.
Okay.
See, Your Honor, my youngest kid is 25. I mean, I know these guys are for child support, but they're for the ones that stay at home that are underage. I mean, they need school clothes, they need stuff for school. Well, when my kids grew 18 and out of the house and moved on, my case from these guys go up to the main headquarters. I mean, I shouldn't have to deal with these guys anymore. I mean, my youngest one's 25. I mean, they don't live around here and they don't go to school anymore.
But Mr. Erickson, so you can understand, these are arrearages. This is the amount of money in child support you should have paid to support your children when they were under the age.
Yeah, but yeah, I know that, but she never really had them because she moved up to Tennessee, left the two boys here, and took the girls there. I had to serve her papers to bring my daughter back here, and somehow that got thrown out of court. I mean,
Mr. Erickson, I'm hearing your frustration. And I do understand that your youngest child is now 25. However, these are arrearages. The only way that this will be taken care of and would be if you pay all of the child support. I think it's $30-some thousand in arrearages, or if Ms. Hess.
I don't know what her last name is. She'd been married so many times.
If Ms. Hess were to waive all of the rest of the child support that you would have owed her. That's the only way. Because if you had an issue and you said, well, she's not really supporting the kids, the two kids live here and in Tennessee, that should have been brought up in 2012 or whenever that occurred. We can't go back in time and we can't now argue that.
But now if I was found in contempt, I would have another court date, but they didn't find me in contempt. I mean, because they let me out on June 15th. Here's the warrant. That was on Father's Day on a Sunday. I mean, so they didn't find me in contempt. Because I would have had another court date if I would have been found in contempt.
You were found in contempt. You were found in contempt a long time previously, and the court did order sanctions. And in order to not have those sanctions of sitting in jail, you needed to comply with all of those purge requirements, those conditions that the court set, such as giving, I think it's 2 job applications a week to child support and paying your arrearage.
I did. I've done all that.
We have one.
I mailed it to him. It was the government center for that county, 7410 County Road K, Saturn, Wisconsin.
Ms. Thomas Schmidt, how many job applications do you have?
We have one sheet with 2 applications, one for the cheese store Burnett Dairy and one for Hardware Hank.
That's because I brought it up to him. Because I knew there somewhere in the road they were going to say something like that. So I had my dad bring me up to him, and I applied at my dad's work. He's back there. I applied at my dad's work, and I applied at CLO. So.
Well, I'm glad to hear that. Make sure you give proof to the child support. With regards to the jail that you sat, you do get credit for that. And I can't, that is what was ordered in the remedial contempt order. And then you ended up sitting that time. So again, the only way that your child support obligation will go away is if you pay all of the amount that you owe their arrearages, or if Miss Hess waives the rest. Okay?
Well, since she got remarried, can't I collect alimony off her? I mean,
No,
since why not?
that's not the law.
Yeah, it is.
It sure is not.
When we got divorced, the other one got married, the other one could surely collect alimony.
That is not accurate at all.
I'm pretty sure it is.
I'm pretty positive it's not. Pretty positive it's not.
Hmm.
And it's not alimony, it's called maintenance.
No,
That's
Big
what it's
Dummy
called?
doesn't work like that.
Yes. And there is nothing in the law that says once your ex-spouse remarries, you get to now go after her for maintenance.
Now he sounds like a
It's
chick.
just not the law.
I don't know. I think it is.
You find me case law and you find me the statute that says that, I'd be happy to hear you on that issue.
Right. But I mean, there's only so many jobs I could fly at. I mean, especially when I don't have a car. All I have is a bike, I can only go so far.
There's a lot of jobs that you can do online if you have.
I don't have a phone. I don't have a computer. I don't have any of that.
Well, hopefully your dad can employ you.
Yeah, well, I mean, I'm doing the best I can. I mean, you can only do so much on a bike. I mean,
So what is it gonna take for you to get your driver's license?
I got my driver's license. I just don't have a car. My car burnt up.
Oh, I remember that. I remember that now. Well, hopefully you can work for your dad.
And then with my record, I don't, it's hard to get a job with my record. I mean,
I just keep hearing excuses.
excuse me, well, look at it. I mean, you get a felony, a lot of people don't hire you with a felony.
I understand that, but Mr. Erickson, just because you had a felony doesn't mean that you can stop paying
I didn't say that.
obligation.
I didn't say that. I'm just saying it's harder for me to get one. But I haven't gave up. I'm still trying. I mean, as you
Applied
can
at
see,
A&W,
where's
they're always
that?
hiring.
Where's that? Siren? Well, I got to ride all the way from Grassburg. I mean, that's quite of a ways, ain't it? Every day. I mean, that is a ways.
You gotta do what you gotta do. And if it means you have to become a triathlon person or
Yeah,
want
well,
to
you
get in
know,
shape and ride your bike,
you know how hot it is out there? I mean, the heat would kill you. I mean, more excuses, right? Yeah.
yes, more excuse.
Yeah, well, I like to see somebody else try that every day, riding a bike in the hot heat. I mean,
Mr.
it's-
Erickson, I'm just gonna be blunt with you. You put yourself in this situation.
no, I didn't.
You did.
No, I didn't.
You didn't?
No, I
You
didn't.
didn't commit the crimes that got you the felonies that
No, I
prohibit
didn't.
you or actually limit your ability to get a job.
No, I didn't.
You didn't get those charges and convictions.
No, I got those charges, but it wasn't from me. I mean, they're all lies that are on there.
All lies. They're all lies. Anyway, okay.
Mhm.
The court is going to credit you the amount of time that you did sit. The purge conditions are back into effect. So all you can do is comply with the purge conditions. Anything you want to add, Ms. Thomas Schmidt?
Just that given the credit, there would be 9 days stayed still.
9 days stayed. All right, so you face 9 days if you don't pay, you don't do what you need to do with the purge conditions. But if those are all set, then you start over.
Oh.
All right, well, I'm sorry this couldn't have been a little bit more fruitful. Just continue to apply for jobs and give those to Ms. Thomas.
You can only apply at so many.
That's what I hear.
Oh, well, how many think they're out there? I mean, how many jobs do you think I could apply at? I mean, I applied at, I don't know how many, about 8 of them already. I mean, there's only so many in the area. I mean, there ain't like 1,000.
I guess you should just give up then, huh?
Well, I haven't gave up. But I'm just saying, how many more, I mean, how far can I can't ride a bike 60 miles? I mean,
You have other
how about,
options.
can I work for, how if I work for this place,
You can borrow money from your father and get a.
They don't
car.
have any money. I mean,
I don't know what else to tell you, Mr. Erickson. I do have to move on with my other cases though on my calendar. So,
but I am doing the best I can. I mean, I'm trying.
I appreciate that. So keep doing that, keep giving it to Ms. Thomas Schmidt, and then hopefully you're gonna meet your purge conditions and they'll all be good to go. Okay?
Well, I'll try. I mean, I don't know.
Yes, that's all I can say.
I don't want you talking to her.
All excuses. Okay, you're
Excuses.
adjourned. Thank you. Thanks for running.
Get out. Well, that was craptacular. All right, I'm going to try to go back now. I'm going to try to go back to the original clip I was supposed to do.
Rory?
Yes, they're back.
Let's see if this works.
They're back?
Yes.
Okay, did they work something out, or are we gonna need a trial?
Is this on ours? We're gonna need a trial.
They're
All
gonna need a
right, come
trial.
on up. Huh?
Yes, they want a trial.
Come on up, guys. All right, and this is, what's the case on this?
This is case, a small claims case ending in 002. Correct. It's a mechanics lien.
I'm sorry, you broke up. Somebody tried to come in at the time. Todd, what's the last three of the case number?
226.
226.
You talk into this. Yeah, let's let this stuff.
All right. So we've got Michael Owens, and then we have got Christine Jacks. Go ahead, counsels for Mr. Owens. Go ahead and get us started. Give me a brief overview of why you're here and what you're asking for.
Yes, Your Honor. So this is at root a very simple case. My client performed some plumbing work for the defendant. She called him off of Craigslist and said, hey, my tenant doesn't have hot water, and my tenant is going to move out if her hot water is not restored immediately. Called my client to come fix the hot water so that her tenant would not move out, and her tenant had, by the way, been searching for other accommodations and so forth. My client then crawled under the house through various really fun substances that he can talk about, but including human waste from a sewage pipe that was broken, and restored the hot water that day. Following that, the defendant refused to pay his bill for restoring the hot water and instead moved the goalposts and said, no, this isn't just for the hot water. This is for changing the hot water and repairing the sewage and replacing a breaker and all kinds of other things. We submitted a demand letter back in February in compliance with 38.001 of the Texas Civil Practice and Remedies Code, submitting our claim. No satisfaction of the claim was made. As a result, we're also asking for my attorney's fees and court costs related to this case, which as of this morning is about 4 hours. There's a counterclaim as well for, I'm not entirely certain because the invoice is about as clear as mud. There's no, I know we don't properly follow the rules of evidence here, but there's no sponsoring witness for the invoice. If you look at it, there's actually, I have some serious questions about the invoice because there's no indication of payment. There's no check stub. There's nothing of that nature. As well, the invoice has two different fonts. If you look at, I believe it's Exhibit B on on Mr. Taylor's filing. I could be getting that wrong. I don't know whether it's A or B, but there's multiple different fonts on the invoice. I'm not clear whether the name on there was written by someone else or it's a signature or what. So I have various doubts about the counterclaim as well. Their counterclaim includes a reference to Texas Property Code 91.109A, which I don't think exists in the Texas Property Code, and I'm not sure what that reference is attempting to invoke. Maybe it's a typo, or I don't know if ChatGPT or what. But there's a reference to the Civil Practice and Remedies Code 38.001, which they did not comply with because they did not send a demand letter of any sort, not to mention they're required to send one 30 days in advance. So respectfully, Your Honor, there is no counterclaim. Attorney's fees for the defendant would be barred in any case. And we're asking for an initial amount of $1,791 in damages for my client's work and materials and time, including an entire day of crawling underneath the house through human sewage and so forth, and $1,400 of my time at $350 an hour times 4 hours, plus court costs and interest.
Okay. Now, the 1791, did he pay somebody to get that fixed, or where did he come up with that 1791?
That's his time for an entire day plus materials. That's the invoice that was originally sent to Miss Jackson. She refused to pay.
All right, Mr. Taylor, go ahead.
All right, Your Honor. Yes, he was hired to do some work. He didn't, and the work was to repack the hot water. My client, when her tenant in number 1 moved out, the hot water in number 2 stopped working. So there was something issue where they weren't plumbed right. And so she requested him to come out and replumb the bathroom to number 2 with PEX to get hot water number 2. That was part of the assignment. The other was to fix the toilet that wouldn't flush well after the second flush. She knew there was a problem there, and she asked him to fix that too. That was the initial assignment. He came over there. He did not repex. He did get hot water working, but he did not repex. And he refused to do the toilet. And so in addition, once she got to that point, she also realized she didn't have hot water number 3, which was working previously. So either he took parts from that or he disabled it. Maybe it was part of guerrilla collection tactics. So she hired somebody else to come out, assess what was going on, and fix it. And this person came out and fixed everything. She's paid him $700 to fix the work that Mr. Owens did not do, or had not done well with respect to the number 2 and the number 3. So we have a claim of $700 that she had to pay for that. She also paid this person a lot more on that invoice. That was to fix the sewer that Mr. Owens did not attempt. So that's not something we're looking for him. He didn't do any work there at all. So this was her bill just for that. She intended to hire a licensed plumber. And when you go to his Craigslist, you see he shows a license 7538 on Craigslist. And then when, after this blew up and she was fighting him, she started to search, and she searched and found that number does not belong to him. It belongs to Jose Medrano. So we don't even believe he's a licensed attorney, even though he's fraudulently holding himself out as one, using someone else's number on his advertising on Craigslist. So we think that's problematic. I mean, it's one thing if you think you're hiring a licensed plumber and you're not. It's another thing if you're hiring somebody else that's not and you know they're not. It's two different decisions. She thought she had a licensed plumber coming out that would be reliable, trustworthy, and get the job done the way she requested it. It was not done the way she requested it. He did achieve some success, but he didn't do it as she asked. And then he turns out he's not licensed. In addition, when the dispute developed, he left the sewer cap off to cause issues with the tenant. He also made other threats to her. I went on her webpage and said things as well. And another thing that's just problematic from an ethical standpoint is after he got the hot water working in number 2, where there's a tenant, he, I guess, figured needed to test it and took a shower, which was really a strange kind of event. A contractor taking a shower in the unit he just repaired. So the tenant reported that back to our client. So, Your Honor, we're seeking today the $700 that we had to pay someone else to finish. And we also don't think their claim was $1,700. We didn't see that until the petition. All the text messages between the parties that we have copies of was talking about $1,200 was his claim. So he also took some locks and keys from the property where she had to re-keys, paid about $100 for that. So I think our total counterclaim is $800. And his claim at best, but then again, that was assuming he was licensed, was $1,200. And we would be seeking attorney fees to defend against that claim. And I know counsel is opposing our attorney's fees on the breach of lease matter.
Okay. All right. Thank you, Mr. Taylor. I do have some questions for opposing counsel. Counsel, can you shed some light on this? Is he a licensed plumber? Is he not a licensed plumber? Shed some light on this advertisement.
Yeah, absolutely, Your Honor. And I assume it's okay if I sit while I respond, or would you prefer? Okay.
Yes, sir. Go ahead.
So he's not licensed. He had an apprentice license at one point, but is not presently. However, he did not pull a permit for this job. I believe Miss Jakes either pulled the permit herself or had another plumber before him pull the permit and perhaps didn't pay that person as well, but he never pulled a permit. I haven't seen anything about him holding himself out as a licensed plumber. That's the first time I've ever heard this allegation. Not to mention it's entirely beside the point. He did the work. He performed what he was requested to perform. In the state of Texas, you can repair plumbing work without a license. You just need the license to pull a permit, which he didn't do. And he never told her that she would. He never told Miss Jakes that he would pull the permit. He never tried to. He never did anything of that nature. Any permits that were on the project, either she pulled herself because she wanted to hire someone without a license because it's cheaper and she could save a buck, or, and I don't know, this is in the defendant's control, so perhaps she could testify to this, or perhaps there was another person before who pulled the permit and then she ran him off too. I don't know.
Okay. Do we have a contract between the two parties?
Only a verbal oral contract with regards to the original engagement. There were text messages that were sent after the original thing happened. And like I said, this is you're going to hear a lot from Mr. Taylor about the sewer line and all that. Those text messages are all sent later, and that's part of the defendant moving the goalposts in order to not pay my client. All right, hire him for A, then say, oh no, really the job was A and B and C and D, and I'm not going to pay you.
Okay. All right. Y'all have anything else to put on, or do y'all have any witnesses or anything, or
Well, we could put on testimony if you like, Your Honor. I mean,
it's your case. So if y'all are done, it's
Well,
up
then
to you
let
what you want to show me next.
well, my client did believe she was hiring an independent plumber. When you look at his advertising, that's what she looked at. She actually had several days of this from February, March, April, and even May. So he's still advertising as a plumber, independent and affordable, with somebody else's license number, which is just, I mean.
Constable, can you get that for me? And Christy, can you scan that in? I need to
There's
see that.
several of them, but it shows the number. And if you run the number on the plumbing board's website, you get the name Jose Medrano, which is not someone that's involved in this case at all. My client initially hired him for both, and knowing that one was a hot emergency and the other one could happen a little later. But when it wasn't fixed the way she asked to be fixed, and she then discovered something else was not working, she held off because she didn't know what her damages would be at that point. She didn't know if anything was fixed or if parts were taken from one or another. But it seems that 3 was just disabled as part of a collection activity. It wasn't hard for her to fix once she got someone else out there to fix. And on her second time, she did not hire a licensed plumber. She hired her foundation guy, which she knew she was hiring a non-licensed plumber, but also there might have been a foundation aspect to this. So that's why she had him come out to review things, and he got things resolved for her, bifurcated his invoice into what was remedial work for the work Michael Owens was trying to do, and then additional work. So I think that's very clear. We're not seeking $4,000. That was, she had a bigger expense with respect to the toilet, the sewer line that she took care of. But she did pay the 700 to the guy. She paid him everything, but 700 of it was put towards the remedial work.
Can I see that $700 invoice?
That's attached to my breach of contract counterclaim.
Got you.
have
And
to-
that's the invoice that council was talking about with
that
the
counsel was-
different
Yeah, this is
fonts
the
and
invoice
stuff.
she received from him. So. And it's signed by Carlos Vega, who was the contractor she hired.
I would also note, Your Honor, there's no evidence that that invoice was paid. It's just an invoice. Presumably the check stubs are within her control.
Okay.
And, again, I know we're not under strict rules of evidence here, but she has the check stubs. And I would wonder why you're not seeing a check stub instead of an invoice.
Go ahead, Mr. Taylor, if you can answer that.
Senator, I'd like my client to testify regarding payment of the invoice. So.
Okay, go ahead.
She needs to be sworn in, or has she been sworn in?
I don't know. Constable, has she been sworn in?
Oh, then you probably did. Did you get sworn in?
Yes.
Oh, then she's ready. Do you want her to talk from here, or do you want her up on the stand? I'm not sure what you can see.
She could talk from there. That way I can get the microphone in here.
Okay. You go ahead and sit down. Okay. Ms. Jacks, you received an invoice from Carlos Vega regarding the work he did on your property, correct?
Correct.
And he did more work than just the remedial work, correct?
Correct.
And the invoice is bifurcated into those two amounts.
That's correct.
How much did you have to pay for the remedial work?
For the plumbing?
Yeah.
$700. And I paid him cash.
You paid him cash, and the whole invoice was $4,000.
Correct.
Have you paid that whole invoice?
Yes,
now?
it's totally paid.
The work was done around April 14th, the date of the invoice. Is that correct?
That's correct.
And he was paid within a week of that, or right after that, or? when did-
Yeah, I give him draws,
Okay,
but as he finishes certain portions, I give him draws.
and so he's fully paid at this point?
He's fully paid, yes.
Okay, and you paid him cash?
Yes.
Okay. All right, Your Honor. That's the testimony regarding the payment on the invoice. So anything else we need to get into?
I did hire a plumber when we first bought the property, and that plumber pulled a permit and redid everything. I was told that a plumber pulls the permit, not the owner, and that previous plumbing permit was pulled, inspected, and passed. So there was no bad work done.
That was previously. Did you ask Ms. Rowlands to pull a permit?
Yes,
You did. He did not.
he did not. He was the plumber. He has to pull the permit.
We understand why he didn't. Now, he's not licensed and couldn't
I didn't know that though.
at the time. Right. You believed, you saw his advertising on Craigslist that said, independent plumber, independent, and affordable with a license number on it, and believed he was licensed when you hired him.
I assumed he was advertising that his number on there and he was a licensed plumber, yes.
And that's what you thought. So when you asked him to pull the permit, you thought he would pull a permit and then would have no problem pulling a permit
That's
for
correct.
your work. So, but in essence, no permit was ever pulled.
No,
Okay. And so he held himself as a licensed plumber, didn't pull a permit, did work, and then you had to have someone come and fix that said work.
yes,
Okay. And the cost of your locks, that keys disappeared afterwards too. He left the sewer cap undone, you testified to, but he also took keys to the units and from a lockbox that you had to reset up, that you had a lockbox for. Is that for workers that would come to the property or
yes.
showings?
Every worker that comes to the property, I change the code.
Mhm.
So it's just me and the vendor that knows the code. When I went back the next morning, there were no key, everything was locked, but there were no keys. So I had to spend $100 in rekeying locks. And then number 3 unit was dismantled. There was no water at all on the hot side. There was a sewer cap open, and it was 9 o'clock at night, and he wanted me to come down and pay him. And he said he wouldn't turn on the water, which I have a tenant.
Right.
He said that sewer smell, he wouldn't cap it, and sewer smell is toxic, okay? And I basically fired him and I had to hire another plumber. And
well, that was your. or did you-
yes,
That was the guy you had,
Yeah.
Carlos Vega, that came.
I had him come because he had done the original foundation, which I pulled a permit for
Right.
at that time. But I couldn't leave the tenant with sewer smells, that's toxic. And she was really afraid of him because at 9 o'clock at night, he had, without permission, went into the shower, stripped down, took a shower, and she's a single mom with 2 kids.
That's just troubling. Your Honor, at this point, I think I can pass the witness. I think we've covered, and then I need to testify a little bit about attorney's fees.
Go ahead, counsel.
Thank you, Your Honor. Ms. Jakes, I noticed you said you paid cash for the second plumber. Did he give you a receipt?
He was the foundation guy.
Oh, sorry, the foundation guy that did the plumbing work. Did he give you a receipt?
Yes,
Okay, where is that?
you have a copy of it there.
Was that furnished to the court? And
Yes,
It's
is that an
just,
invoice or a receipt?
that's the final invoice.
Okay.
it's the invoice.
Does that indicate that cash was paid, or does that just indicate the amount that was due?
It was paid by cash.
Okay, so did he give you something that showed that you paid cash?
I believe it says paid in full.
Does it? Can you point that out?
I'm
for-
not
for-
looking at it right
No, this is just an invoice. It doesn't show
Um,
paid in full.
So it did, just to understand, it does say paid or it does not say paid on that invoice?
now. I see it. Okay, it says due upon receipt.
Mhm.
Okay, but it was paid in full.
Where is it? Can you point out to the judge where it says it was paid in full?
Um, I did have another, I don't have it with me. I do have another draw sheet that he signs every time I pay him. If we
So-
could get that.
So there is a draw sheet that says that
Draw sheet,
there
yes.
is. Okay. Why don't we have that today? Why didn't your attorney furnish that to the court?
I didn't know we needed it.
Okay. So we're here over, fighting over a few $1,000s, and you didn't think that it would be something that the judge would like to
Yeah.
know.
This is a bit of badgering of the witness. She answered his question.
I think it's relevant.
Sustained.
Okay, fair enough.
Sustained. She answered the question. I get your point, counsel. Go
Good
ahead.
deal. Ms. Jakes, what was the name of the first plumber you hired that you indicated pulled a permit and did some work?
Mm.
Your
I'd
Honor,
have
I
to
would
look that
object
up.
to relevance. This
It
is
was a
not
couple
even.
years ago.
Yeah.
Okay,
this is-
hold on.
I would object to relevance. This is years ago when she hired a plumber to do work when she initially bought the property. This is not something relevant between these parties right now and the transactions.
Counsel, where are you going with this?
Well, I think it's relevant since such a big deal is being made about permits. I'd like to know who it was that pulled the permit the first time. They're gonna stand up here and say that, it's the end of the world that my client didn't pull a permit and that he is
I'll
not a
allow it.
licensed plumber.
Go ahead.
Yeah. Do you remember the name of the first plumber that did pull a permit?
Bring up my phone, but it's all listed with the city. All the permits and completion and the inspections for the roof, the foundation, and the plumbing are all there, and we can get those.
Okay, fair enough. But you don't remember the name?
I have to look it up, and I turned my phone off out of respect
No,
for the
that's
court.
that's fair enough. That's fair enough. So I want to talk about a little bit the foundation guy that did the plumbing. Is that Carlos Vega? Am I remembering that correctly?
Yes,
Okay. And he's not a licensed plumber though, right? Okay. So is it your testimony that it's important for you to have a licensed plumber work on your plumbing?
it's my testimony that if I hire a licensed plumber, he'd be a licensed plumber.
Okay.
Whereas my experience with Vega, he's worked for me for years, and I had confidence in him that he would get it done in a quick manner so my tenant wouldn't suffer.
Even though he's not licensed?
That's correct.
Okay, fair enough. How do you know Carlos Vega?
I hired him. I have multiple properties, and I hire him for my foundations.
Okay. Is it true that he's your tenant's boyfriend?
Carlos Vega?
I-
No, he's not.
He's not.
He's not.
Okay. And let's talk about the invoice a little bit that I have some questions about. On the invoice, it says fixing hot water for units 2 and 3, and then it has some foundation work. And then $700 for unit 2 and 3, correct?
Correct.
But you hired Mr. Owens for unit 2, right?
No, he was hired, I showed him unit 1. And when unit 1 moved out, the bathroom in unit 2 did not work. The kitchen worked, but the bathroom didn't.
I'm sorry, I'm talking about the hot water. The
I'm
hot water.
talking
for
about
unit
the hot
two?
water.
Okay, so is the hot water for unit 1?
No, when unit 1 moved out and turned off electricity, unit 2 no longer had hot water in the bathroom.
Okay.
In the kitchen they had, but not in the bathroom.
Okay, so then you hired my client to fix the hot water for unit 2, right?
I hired him to repex the hot water. So when unit 1 moved out, I wouldn't have this problem again
To repex the hot water for the whole house or for unit 2?
for the bathroom in unit 2.
Okay, good deal. So then I'm looking at the invoice for Carlos Vega. It says unit 2 and 3.
Yeah, unit 3, when I went there after the fact and I didn't have keys, I had to rekey. And then I went into unit 2, he had dismantled all the hot water and he wasn't even supposed to be in there. There was no water coming out of the hot water side at all.
Okay.
He had rags in the toilet. He had brown stuff on the wall. He had made a mess and he had dismantled it. And with threats that he was going to make it miserable unless I come right then and there and pay him.
Okay, fair enough. So do you know why Carlos didn't break up unit 2 versus unit 3 on his invoice? Why does it say unit 2 and 3 together? Why is it just one block charge?
I have no idea.
Okay, fair enough. And again, Carlos didn't pull a permit for that, did he?
No, he's not a licensed plumber. I hired him because he was the foundation guy.
But you're okay with that, with Carlos not pulling a permit?
I'm okay knowing that he didn't have a plumber's license and I was hiring the foundation guy.
Okay. And so you were okay with, fair enough. No further questions, Your Honor.
Redirect.
Go ahead, Counsel.
You hired him for unit 2 to repex the bathroom for unit 2, Mr. Owens.
I hired him from unit 2 knowing that it was connected to unit
Right,
1.
And then after this dispute developed, you discovered that something had happened in unit 3.
That's correct.
Things had been dismantled. That was unit 3. You were discussing that the things were dismantled in the rags.
That's correct.
So then the invoice is to finish the work that Michael didn't do and to repair the damage Michael did do in response to you not paying the invoice.
That's correct.
I guess is what his complaint would be. So that's why the invoice says 2 and 3. That was the plumbing work related to Mr. Owens.
That's correct.
The 3,300 was more foundation and plumbing work for the sewer that he did not attempt.
That's correct.
So we're seeking that from him.
That's correct.
All right, Your Honor.
Your Honor, I'd like to offer a short little bit of testimony from my client as well.
Go ahead, Counsel.
Okay. I call Michael Owens, and I believe he needs to be sworn as well.
Mr. Owens, have you?
Any relation to Laura?
Did you swear?
Yes, sir.
Okay. Michael, just a couple of questions. Your invoice was for 1,791 for this job, correct?
No, sir, it was 1,200.
1,200. I'm sorry, my mistake. And you were there for how many hours, would you say?
I believe we got there around 10:30, 11 o'clock, and we left around 1 o'clock in the morning.
Okay. And do you remember approximately, it doesn't need to be down to the penny, more or less, what was the split on that 1,200 between labor and materials?
Materials were about $136, and then I paid my helper $200, and then the rest was labor.
Okay, good deal. And do you have a sense for the court for that kind of, well, I'm sorry, one more thing. That labor for this, that involved crawling underneath the house through sewage, correct?
Correct, both of us.
Okay, which, most of us might charge a little bit extra to do that, right?
A lot more.
Okay. Do you have a sense for if another plumbing company had been hired, or what would another plumber charge to do what you had done?
Probably about $6,000
Okay, and why is that?
because of the elevation of the house, how low it was. There was human feces or human, human, doo-doo everywhere up underneath
Sure.
that house. And which, that right there, in itself is worth, several thousand.
Okay.
That,
All right.
so that's just what a plumbing company would have cost, was about $6,000.
Fair enough.
You have doo-doo on your car,
hire
you
a
can go ahead
licensed
and check
plumber who
that.
would have pulled the
Well,
permits and all that.
Yeah, then that's not including the permit. That would have been $900.
Okay.
But in the state of Texas, you don't, the homeowner can pull their own permit.
Right.
And they can hire whoever they want in the state of Texas.
Understood. That's my understanding of the law as well. And last question, and this is kind of the most important part here. When Miss Jax called you for the first time, she called you from Craigslist, right?
Correct.
And what was that initial conversation?
Hot water.
I'm sorry, can I just so the judge can hear it clearly? What was her initial request?
Her initial request was hot water.
Did you talk about the toilet or the sewer
No,
line or any
no,
of that?
sir. Not until she threw that in after I got there, a couple days later.
Okay. And you understand you're under oath. You're swearing that this is true, correct?
Yeah, it's on text message.
Okay, absolutely. And so the initial conversation was about hot water and nothing else, right?
She threw, the initial conversation was nothing but hot water. But once I got there on site, she started throwing some things in, and I'm like, look, ma'am, we're going to focus on the hot water.
Because that's what she told you.
Because your tenant is going to leave, like you said. So unless she gets hot water. So we're going to focus on that. We're going to take that one, and then we'll worry about the other later.
Okay. And was there ever any discussion or did she ever give you a written contract or anything like that?
No, sir.
Okay. And y'all never discussed being paid after everything was done?
No, sir.
Okay. And
There was never no discussion of payment, prior to when I left at 1 o'clock in the morning.
Understood. So, and let's if you gave her an invoice after the hot water and the crawling through feces and all that, and she told you that she wasn't going to pay it, right?
Correct.
And is there, if somebody told you that they weren't going to pay your invoice, would you come back and do more work for them?
I wouldn't.
Okay. Why not?
Why? You didn't pay me for what I've done.
So why would they pay you for the second one?
Correct.
Okay. Your Honor, no further questions. Pass the witness.
A few questions. Mr. Owens, you're not a licensed plumber, correct?
No, I'm not. At one time I was.
Why do you advertise on Craigslist?
That's irrelevant. Who cares?
Sir, I'm asking a question.
Okay.
Why do you advertise on Craigslist and put a plumber's number that's not
Okay,
yours?
I thought it was my apprentice number. That's
Okay, all right, Mr. Owens. Let him ask the question and answer it.
So
go ahead.
You've done this. I mean, you might have done this for years, but we have evidence you've done this for months, at least this year, because of my client's involvement here with you. But that is not an apprentice plumber number. That's a licensed plumber number. And if you run that search, you get a Jose Medrano. So why do you do this? I mean, you could certainly say, I'm a handyman and I do plumbing work. I do electrical work. I'm a handyman. I'm not licensed, but you say you're licensed. Why do you say you're licensed and include a license on your advertising? Do you want to give a false impression to people so they hire you?
I've been doing plumbing 17 years.
But you could say that and not put the
And I mean
license
that.
number on there.
And I mean that.
Well, you claimed 20.
Is that why
Here.
we're in court?
I've already spoke to the plumbing board because she called the plumbing board and I've already spoke to them. I've already spoke to the plumbing investigator. So that's really my business between me and the plumbing board.
It's your business between you and the plumbing board for that, but it's your business with the world when you're putting this out
She
there.
wasn't too worried about a licensed plumber because she didn't hire one after me.
No, she hired somebody she trusted after you.
Your Honor, I'm going to object to relevance. There's no claim for a false plumbing advertising or anything of that nature. If counsel could get to the point.
Okay. All right. So,
I think I've
counsel,
got
I
enough
get
of
where you're
that.
going.
And further, you said you sent a $1,200 invoice.
I did.
How did you send that invoice? Did you email it? Where do you have paper?
SMS.
You text. Did you text an actual invoice or
I
did you
did.
text an amount?
An invoice. I text her an invoice through an app. I did.
I've looked through your text messages. I see $1,200. I don't see an invoice. So
That's not my fault.
What does your invoice look like?
Do you want me to show it to you? I mean, you went through the text messages, right?
Mr. Owens, let's back off with the attitude, first of all.
I don't know how to answer his
Okay.
question besides the truth.
Well,
Okay, if you don't know how to answer it, then just say you don't know how to answer it. But you need to drop the attitude, first of all.
Yes, ma'am.
And
Yes, ma'am.
answer the question. If you do not know how to answer it, simply say answered, asked and answered. That's it.
I sent the invoice SMS text message through an app.
what app?
A link. There was a link
What
sent to
app
her phone.
what app do you use for that?
Joist.
Joist.
Yes, sir.
Okay. All right, Your Honor. I'll pass I'm done with the witness.
Okay. Counsel, do you have anything else?
No redirect. Thank you.
Okay. Does anybody need closing arguments?
Briefly, I guess 2 minutes.
Go ahead. Go ahead, Counsel Taylor, and we'll finish off with counsel for Owens. Go ahead. If anybody doesn't have any more witnesses.
Well, Your Honor, one thing, I just need to testify about attorney fees of defendant.
Oh, yes. Go ahead, Counsel.
Your Honor, I've been a licensed attorney since 1995. Been practicing real estate pretty exclusively since 2005. And my billing rate is $325. And I think considering defending a suit of this nature, going through the evidence, preparing an answer, appearing here today, I believe that 4 hours is a reasonable amount of time on that, including drive and appearance time. So I believe I have a claim of $1,300.
My God, that's light.
My attorney fee would be a reasonable fee for the work done here today defending.
Go ahead, Counsel.
Yes, Your Honor. If you'll permit me one moment, I'm pulling up.
Yes, sir.
I apologize. Okay, Your Honor. Two things. First of all, as you saw, my client might be a little bit rough around the edges, but at the end of the day, the fact of the matter is he did the work that was requested, and he hasn't been paid for the work that he did. And that's the story here, despite whatever distractions and red herrings that we want to throw up about licenses and other work that was done. He was requested to do some work. He wasn't paid for it. That's the story. Second of all, I want to briefly read you, Your Honor, from section 38.002 of the Civil Practice and Remedies Code, which provides that to recover attorney's fees under this chapter, the claimant must be represented by the attorney. The claimant must present the claim to the opposing party or to a duly authorized agent of the opposing party, and payment for the just amount owed must not have been tendered before the expiration of the 30th day after the claim is presented. That's from the Texas Civil Practice and Remedies Code 38.002. No presentment of claim was ever made by Mr. Taylor, therefore attorney's fees, even if he is as right as the day is long, attorney's fees are completely barred here. There was no presentment, and that's not optional. That's a procedure that we're required to follow. That's why my office sent them a letter in February. Likewise, I would add my own testimony that I have been a licensed attorney since 2011. My standard billing rate is $3.50 an hour, and I think 4 hours, like Mr. Taylor's time spent, is a very reasonable estimate for a total of $1,400.
All right, guys. So after hearing testimony from both sides,
Your Honor,
you're-
a small closing argument here. Just
Go
on
ahead,
my-
Counsel.
Okay. Your Honor, thank you. Yes, there was some work done. He misrepresented himself as a licensed plumber to do it. My client then had to do remedial work, and so wasn't sure exactly what damage he had done or how she was going to come out. And we've been able to determine recently here, and especially today, that, well, he did $1,200. Our claim is about $800 for the remedial work and the locks that disappeared. So they have a net claim at best of $400. And I'm not arguing attorney's fees under 38.002 on our counterclaim. I'm arguing purely as a defense to the claim that he has, which we've argued here and substantially reduced and had success. So I believe my fees would be recoverable as piggybacking on his to defend against his, not claiming for our breach of lease and asking for attorney fees for that document and claim. So, Your Honor, I think that's just a bit of the nuance with it, but I think I'm entitled to him against his claim since he's claiming attorney's fees. So, Your Honor, so today we're seeking, we're generally request to take nothing judgment. There's been enough going on here that all sides can just walk away from this. It's been an uncomfortable experience, I think, for everybody. But of course, we think you'll make a just decision in this matter. And so, Your Honor, with that, we will rest.
All right, after hearing both sides and closing statements, Counsel Taylor kind of pretty much hit it on the nail at the end. At this point, I am going to go ahead. I've heard testimony from both sides, and it does look like both sides have tried to cut corners at some point in this relationship. You know, Michael Owens, you did a job. You sent an invoice. However, we cannot populate an invoice. It was on some app that nobody's heard of. I have yet to see an invoice at any point for the $1,200. Second of all, obviously we have the licensed or unlicensed plumber. Again, you're dealing with that on your own as far as the board of the plumbing board, and any other repercussions you have on that. But I'm telling you, Mr. Owens, if you are portraying yourself as somebody you should not be on Facebook, then again, you're dealing with the repercussions of those sanctions. Miss Christine, I've dealt with you multiple times during evictions. You're not new to the court. You obviously are well aware of what's going on. And for you not to have a contract or any proof or any invoice of the $700 that was paid, you know how this court is run, and we're run strictly on proof. We have no proof that $700 was paid. I do understand it was mixed in with another invoice that you currently have just finished paying with a bunch of other jobs that you have tied into that. But nonetheless, that we're here today and you're wanting claims for a certain amount of money, and we don't have proof of that. So at this point, both counterclaim and original claim are both take nothing judgments. Thank you.
Thank you, Your Honor. And by the way, Your Honor, this is my first time in your new court. It's a great building you have here.
Thank you very much, and I'm glad everybody found it somewhat in time.
Marlon is back.
He owes us nothing. But okay.
Everyone loses. The way I
All right, Mr. Steven, go
and
ahead
that
and give
is-
me a brief overview of why you're here and what you're asking for.
Neither the claim or the counterclaim was proved.
This is my
That's
cousin. I signed a power of attorney over to him. I was in the hospital at the time this was put together. So with your permission, I'd like for Lloyd to speak on my behalf. Is that all right?
That's fine.
Okay, Your Honor, my cousin Steve,
The plaintiff was living in Mesquite, Texas, and he wanted to move back to San Antonio. And the defendant, who we have all known for over 22 years, contacted him, said, I have a house, you can lease it for $1,000 a month with $1,000 deposit. So she forced him to make an arrangement so that his bank would automatically send her $1,000 on the first of every month. She wouldn't accept checks or any other payment. So we came down on August 2nd with I drove the U-Haul. He followed us in his car with the dogs. We pull up to the house. There is a RV in one side of the driveway, a trailer in the other side of the driveway, and the defendants were still living in the house. So he couldn't move in. He had to come back the next day. He had hired workers. He had them come back the next day, had to talk to U-Haul, extend the lease, spent the night at our house with me and my wife. And then he leased this home with the impression that they were moving back to Arkansas, the defendant and her partner, Paul, who is not here today. Instead, they moved into the RV and they were living in the driveway. And for the entire length of the time that my cousin Steve, the plaintiff, paid $1,000 a month rent for the premises, he was denied access to the driveway and the garage. And we asked them multiple times to please move the vehicles. Well, basically leave. He was under the impression she was moving back to Arkansas. She stayed in the house, in the driveway, in that RV with the trailer the entire time he paid rent. She never left. She was coming and going, and her partner, Paul, would come and go in the house, use the shower. This guy, Paul, stored 2 cats in one of the bedrooms. He had no access to one of the bedrooms. He had people coming and going. He never, ever, ever felt that he had a home. He never even unpacked because he was waiting for them to leave. In February,
So right now, what is Mr. Stevens asking for?
we're asking for her to return the entire amount of rent that he paid, because he never, ever had the privacy that is indicated in the lease. And
Which is
we're
how
asking-
much?
There's 8 months rent plus a deposit. That's $9,000. And I am also asking $11,000 in punitive damages, because the whole time he was there, he had AFib. He was not well. And I believe they took advantage of that. We called, I had to call the police. Myself and these 2 gentlemen here went over to his house to clean his house for him while he was in the hospital. And I was afraid we were going to have a confrontation with the defendant. So I called the police. The police came out and says, look, there's nothing we can do. Go to assault claims court, but you should call Adult Protective Services, which we did. And we talked to them for months. Nothing ever became of that. But I am asking for punitive damages because my cousin was ill. And I believe that they took advantage of his generosity. They stowed cats in his bedroom, denied him access to his house, kept coming and going. He had no privacy. And I think that he deserves punitive damages for this, because he never, ever felt at home. He wasn't leasing a house, he was leasing a home. And you have—
Lloyd, give me a copy of that lease for me. Constable, if you want to give it to my clerk to scan in.
Yes, ma'am.
All right, and give me 1 minute, okay?
I also have photographs to give you a better idea of this, showing the vehicle and the trailer in the driveway. And I took probably 30 photos over the course of the lease.
All right, give me 1 minute.
And they're still there.
Give me 1 minute.
Yes, ma'am.
Ms. Cheryl, go ahead.
Good morning.
Good morning.
Yes, Your Honor, I would like to say that I object to Mr. Lloyd representing Steve, but furthermore, he led me on the impression that this case was about a certificate of occupancy, and he has been threatening, pushy, aggressive. He's created tons of damages to my house. Steve did move in. I got my stuff out. Lloyd just told a lie. He said that he couldn't move in and he had to reschedule the U-Haul. That wasn't honest. Honestly, what happened was on August the 1st, the beginning of the lease, Steve and Lloyd drove up and Steve called U-Haul because he contracted workers to unload his U-Haul truck. And when Lloyd and Steve checked on the U-Haul, where was it? They weren't there on time. They had overbooked and they asked if they could come the next day. And Steve said yes. So I asked Steve if it would be okay for me to get the rest of the stuff out of the house. There wasn't that much left in the house, but I said, I'll get the rest of the stuff out of the house and I'll make it up to you. And he said, okay. So he did go with his dogs to Lloyd's house and spent the night. And when he came the next day, that's when the moving help unloaded his goods.
Okay, so Ms. Cheryl, this is besides the point. My question is, when did you move out?
I moved out August the 2nd. All of my stuff was out on August the 2nd.
Okay, and where did you move to?
I have a trailer that I'm loading all my stuff up because I'm moving to Arkansas and all of my stuff was in the garage, but we got it all out of there. And the movers put all of Steve's stuff in the garage with the exception of a couple of pieces of furniture in his bed. And they moved that into the bedroom and the living room. And
So when
Steve
did you
said-
move to Arkansas?
I have been moving to Arkansas for a couple of years, to be honest with you, Your Honor.
So you have not moved in yet. You are still back and forth on this property. Is that correct?
No, that's not correct. I moved to Arkansas in 2021.
Ma'am, are you a
taking care of my
whore?
mom and dad. My sister was overseas. When she finally got to Arkansas to help me with that is when I put my house up for sale. And it had everything in the garage that I wasn't able to move up to Arkansas when I moved up there. So I went back to sign the papers to sell the house. I had a buyer. And at that time, the buyer backed out all of a sudden. So that created an issue with me. And then my dad got real sick and he died. I had to go back to Arkansas to attend to that activity, unfortunately. And when I got back, I continued to throw out stuff and get things in the trailer, but I continued to have issues with my health. And Steve said it was perfectly fine with him. I could take my time. He understood about heat exhaustion. He never told me he was sick. I had no idea that he was ill. And when
So your testimony is he let you stay on the property while you rented it to him?
Yes, he did.
And of course, none of this was put in writing, right?
Yes, it was.
Okay, does anybody have?
Sorry about that. They just pulled it. I was going off the live. But Zach sent this to me. I don't know what's going on. Because I was streaming.
All right, Mr. Browning, if you could please unmute. We are just waiting for Mr. Lewisell to join. If both parties could please unmute and turn on their video feeds, if possible.
Hello.
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 All right, we're here in 25S000100. We have the plaintiff, David Lewisell, present, and we have defendant Ricardo Browning present as well. However, is it Richard or Ricardo?
It's Richard.
That's weird. In our system, there's an O added to the end of it. So Richard Browning. So I see that both parties are present. However, Mr. Lewisell, you did not file documentation for proof of service that you served Mr. Browning.
I was served 8:45 last night, Your Honor.
Yeah, it wasn't until yesterday. I haven't been able to find him, Your Honor. It's every time it's been, and it wasn't him that hit me either. It was somebody else driving
I'm
his
sorry, I'm
car.
just here to talk about procedural stuff.
Okay, all right.
So Mr. Browning is here. He said he was served, so I don't quite understand your statement that you're unable to find him if he is here. You do need to file proof of service with the court. That is a document that you need to download off the court and you need to file with us. So that's what we need to proceed. And also, sir, if Mr. Browning is not the correct individual that you could obtain money from, it would be upsetting if we went through this whole process only for me to have to dismiss it when we get to trial because he's not the right individual that you should be suing for money.
I don't know the man's name. He was in, the guy that hit me said that he was a off-duty police officer and that he was studying to be a cop. And I didn't call the police when I got hit. I went home.
So you don't know who actually hit you, sir? So how did you come up with Mr. Browning?
I don't know the man's name.
Mr. Browning, do you know?
So he was a cop studying to be a cop? I'm skeptical.
Who Mr. Lewisell is?
Your Honor, I sued Mr. Lozelle 2 months ago because I paid for a vehicle and he didn't receive it. The judge gave me a ruling on it. He asked to go through court again and he didn't show. And now I'm hearing this. I've never heard of any wreck or I don't know anything about what he's talking about. This is the first I've heard about it. Since he got a judgment against him for not paying me, giving me the vehicle, I haven't heard anything until now. I'm just got this last night.
Mr. Lewisell, is Mr. Browning the individual who hit your car?
No, he's not the individual that hit me. He was in his vehicle that hit me.
No.
Yeah, that's just what I've been told. I don't even know.
So you don't actually know, because if we go forward with the trial and it turns out that Mr. Browning has nothing to do with this, that would be an extreme waste of judicial resources.
It was not him driving. It was somebody else driving the car.
Mr. Browning, do you know who was driving the car that hit Mr. Lewisell?
No, I don't have a car. I have trucks.
It
That's
was
not
a
my
truck.
question.
It was a white truck that hit me.
You just said a car.
Okay, well, regardless, Mr. Browning, I am asking you right now, are you aware of Mr. Lewisell, an individual that hit him in a truck or a car?
Absolutely not, Your Honor. No, not at all.
He
This is the
took me
first
to
I've heard of
court
it.
for the accident, Your Honor.
This is the first I've heard of it.
He took me to court for the accident that happened. That's what, and I had missed the court because I couldn't get my phone to go on the Zoom. I wrote a letter to the judge, but they sent it to my address to where my house burned down. I wasn't living there.
Okay.
Well,
Your Honor, the case that I filed against him was not for a wreck. It was because I paid for a vehicle that he never gave me.
No,
and that's why
not
I sued
true.
him for it. If you look at the court documents, I paid for a vehicle. He never paid me for it. And that's what I got the judgment for. It had nothing to do with no wreck.
Hey, guys, thank you. 1 second, please. 1 second.
I don't know anything about buying a vehicle for me.
Okay.
I got
All right.
hit.
Thank you. Do you have your case number, Mr. Browning? The old one?
No,
I missed the court date.
No, I don't, Your Honor. That was a few months ago. When I got the judgment, I don't have that
What is
information
he
in front of me.
talking
No.
about? I can't believe this.
It's the last judgment. The last time I went to court on this was I filed for the suit. He didn't show. Then he asked the judge to give him another option. He didn't show up for that. The judge said it was finalized.
I didn't know anything about the other option.
If both parties could just stop talking for a second, I'm just trying to figure out.
I apologize.
I'm just trying to figure out what's going on because
I don't know what the hell's going on. I can relate to the judge here. I don't know what's going on. I don't know if an accident happened. I know nothing.
I will not preside over a case where Mr. Lewisell is filing a claim and saying that he is not even aware if this is the right individual to be suing, and then the defendant, Mr. Browning, telling me that I'm not the right person to be suing. That just seems like such a waste of judicial resources.
I understand.
Mr. Clerk, were you able to find the other matter? Yeah. Yes, please. 24S 212. Okay, thank
I
you.
don't know what he's done. He didn't buy a truck.
All right, let me pull this up.
I can just say I bought his car. He's lying.
I would go the other way though. I just let it go to trial. This guy can't prove it. Let him say whatever he wants to say. He doesn't know who is driving the vehicle. He can't prove that this guy owns the vehicle. And then, judgment for defendant. Done.
To me.
Okay, I
He's
can hear
lying.
everything. If everyone could just please
Oh.
mute
Oh,
if
I'm
they want to
sorry. I'm
talk about
sorry.
stuff behind
I'm sorry.
for a Ford Ranger pickup. Okay. I just think the other matter is completely distinct from this one. Mr. Lewisell, is Mr. Browning the right person to be suing? Because if he is not the individual who was driving or who hit you, why are we going to trial on this?
He took me to court for it because I kept asking him the guy's name that was driving his truck, and that's when he sent me to court for the accident. And he wouldn't give me the guy's name that was driving it. It was Mr. Browning's truck that rear-ended me, but it was a young man that was driving it. But he said he was a off-duty police officer or
Okay,
something.
I heard that, sir. I'm not talking
Yeah,
about
it was
that.
just-
So you will be able to prove that it was Mr. Browning's truck that hit you.
Yeah, that's who sued me. Yeah.
No, that's not what I'm talking about, Mr. Lewisell.
Yeah.
If we go to trial on this, you will be able to prove that it was Mr. Browning's truck that hit you.
I don't. Yeah, because he's the one that took me to court. Yeah, he took me to court for the accident.
Well, I'm filled with confidence.
No, he didn't. He took you to court to get for a truck.
I don't know nothing about that. That's something that I've never heard of. I don't know anything about buying a truck. And that's somebody lying. Nobody bought a truck from me.
Deal was for merch digs and track for a Ford Ranger pickup. I can't really read your writing, Mr. Browning.
I've
Deal
never
with
owned a Ford Ranger.
merchandise in truck for a Ford Ranger pickup. Is that what it says?
It says he was given merchandise in trade for a truck.
Okay.
No.
He received all the merchandise, truckloads of it, and then when it came
What are
time
you
to get the truck, he had every
I
excuse
bought
why I
all
couldn't
that
pick it
stuff
up.
from you.
I never
Are
received
you
the truck, and
serious?
that's when I filed the court case.
Are you serious?
Absolutely.
You're lying out your ass, mister.
Okay, please don't talk like that.
I
This is a courtroom.
apologize. I apologize.
All right. I
He's
cannot set this
lying.
for trial yet, Mr.
This is
Lewisell, because
ridiculous.
you did not submit an affidavit of service. We will set this over for 2 weeks until the 30th, July 30th. In that time, sir, you must file an affidavit of service or else this case will be dismissed.
Yes, ma'am.
So you have until July 30th, Mr. Browning, Mr. Lewisell. We will be present at 11:30 in this courtroom, July 30th. On that date, Mr. Lewisell, I must have an affidavit or a proof of service filed with the court so that we may proceed, okay?
And can I come in person, like in the courtroom?
There is no personal courtroom. This is via Zoom right now,
Oh.
sir.
Okay. All right then.
Okay.
Um,
Please file that documentation. I will see everyone back on the 30th
Okay.
at
Let me write
11:30
that down
a.m.
one more time. Can you give me the name of what I have to file for?
Proof of service or affidavit of service.
Okay. Thank you.
Okay.
Thank you, Your Honor.
All right. See you on the 30th, both parties.
Yes. Yes, ma'am. Thank you.
Thank you. All right. If we could just call in then. Thank you for finding that case. Let's call in Alvarez.
Okay, good morning.
Good morning.
This is also
We
Alyssa's
have
fault.
Ms. Talene back in courtroom. Ms. Talene, can you tell me who we're speaking to
This is
today?
Mr. Hallett.
All right, good morning, Mr. Hallett.
Good morning.
So, Your Honor, Mr. Hallett, we also saw on Monday, he was
Right.
given PR bonds. He was not given PR bonds on his state court cases. While he does believe he's going to be able to bond out on those, now he's basically got credit for time served. So he'd like to go ahead and take care of his municipal cases.
Okay, and I certainly understand that. So, Mr. Hallett, you had previously hadn't entered pleas to these charges, but it now sounds like you'd like to plead guilty to the 2 charges that have been presented against you. They're both prohibited items charges. The prosecutor's asking for a day of jail on each of those, so you would get credit for the time you've been in custody, and your cases would close if you decide to plead guilty. Is that what you'd like to do?
Yes.
When you plead guilty to these charges, you're giving up your right to trial and all of the other rights that Ms. Talene has described to you. Do you understand that?
Yes.
Are you doing that voluntarily today?
Yes.
Is anybody forcing you to plead guilty?
Nope.
Are you under the influence of any medications or drugs or alcohol?
Yes.
You are?
Yes.
You are under the influence of drugs or alcohol today?
Librium, yeah.
Okay, is that affecting your ability to understand what we're doing today?
A little bit.
A little bit. So let me just share with you, I have to be comfortable that you understand what you're doing before I can accept guilty pleas. And so if I can't be comfortable with that, you understand that you're making a voluntary decision and that you're choosing to plead guilty to a charge, I can't accept the guilty pleas, and then we would have to continue the case over to another date. So I'm happy to do that. You'd still be eligible for PR bonds.
That's what I was going to suggest, is maybe we could just leave the PR bonds in place and then bring it back on Friday. Because I actually now have some concerns.
Yeah, I think that's what we need to do now. Let's talk about the medication that is this medication that you were on before you came to the jail, or are they still, is it medication you're getting at the jail?
I'm getting at the jail.
And what is it called again?
Librium.
Librium?
Yes.
I've heard of that, but I'm not sure what, how the impacts of that are on people. Do you
For
want to have another
alcohol
conversation with him
withdrawals.
briefly, Ms. Talene, or do you want to just reset this for Friday and see how defendants?
I think we can just reset this for Friday. He's got the PR bonds in place. So if he's able to bond out on the state court cases, these cases won't be holding him and he can appear out of custody.
Okay, and see, and he would be in
Yeah.
custody anyway if he doesn't post bond, so it's not, we're
Yeah.
not punishing him for that. Okay, so Mr. Hallett, we're going to try again on Friday to see if we can resolve your case. If you post bond between now and then, make sure you look at our paperwork, because then you'd still have to come to the municipal court to address these cases. Do you understand that?
For the Albert County stuff, would I be able to post bail here in the Boulder
You're gonna
County
have
jail?
to talk to the jail in Albert County about that. I'm not sure what
Right.
their policy is. I will tell you that I think you should be able to do it, but you're gonna have to ask the jail how you would do that.
Probably will be able to. would be my
Yeah.
expectation. Okay, so we'll Fernando, we'll look and see if the defendant's still in custody again on Friday, and that should be Judge Hill that will be handling the Friday docket.
Nobody can give me a straight answer on this shit, bro. I'm tired.
Well,
of
we're
it.
not Albert County,
I
so
don't
they have.
care. You're the
All right, well,
government,
let's
right?
hold on a moment. Mr. Hallett, we're going to see you on Friday.
All right, I'll see you on Friday then.
Okay.
Stay seated.
I mean, they really are harshing his mellow.
Okay, good morning.
Good morning, Your Honor. This is Mr. Kerrigan.
Good morning, Mr. Kerrigan.
I was able to speak with him and he would like to accept the city attorney's offer today.
All right, and Mr. Kerrigan, this is what I understand the offer to be from the prosecutor, and you can confirm if this is your understanding as well, that he's indicated that if you were to plead guilty to the 2 trespass charges that are pending, that he would be asking the court to impose 10 days of jail on each of those charges, which with a total of 20 days of jail. 8 of those days of jail would be suspended, which would mean you'd have 12 days left to serve and get credit for any time that you've been in custody. So I want to make sure that you understand that that's the offer that's been made. Is that your understanding?
Is he gonna eat
it? Yeah. All right. When you plead guilty to these charges, you give up your right to trial and all of the other rights that Ms. Talene has described to you. Do you understand that?
Yeah,
Are you doing that voluntarily today?
probably.
Well, is anybody forcing you to plead guilty?
No,
All right. Are you under the influence of any medications or drugs or alcohol today?
I am not.
All right. Thank you for that. Sir, the first charge is case number 252938. It's a trespass charge allegedly occurring June 14th of 2025 at 1711 29th Street. Do you understand that charge?
Yeah,
And Ms. Talene, would you waive a factual basis for that charge?
Yes, Your Honor.
How do you plead to that charge of trespass, which is a violation
Oh.
of section 543 of the Boulder
I
Revised
believe
Code?
it's guilty.
I'll accept that guilty plea. Any comment from you, Mr. Altenberg, before I impose sentence?
No, Your Honor.
Any comment from you, Ms. Talene?
No, thank you.
Okay, then I will go ahead and accept the plea, and I'm going to impose a sentence here at this time. Case number 252938, I'm going to impose 10 days of jail, suspending 4 days of that jail sentence on the condition that defendant not go back to the 1711 29th Street, which is the 29th Street Mall, for a 1-year period.
Good.
If you go back, you might face additional jail time. So I want to make sure that you understand that.
That's wonderful.
All right, let's go to case number. I am going to waive court costs and give credit for time served on that case. And then we'll turn to the other case, which is case number 252866. This case alleges that you committed the offense of trespass at that same location. It's at 29th and Canyon, but that is the same location. And this was on June 9th of 2025. Do you understand that charge?
I do back in 2005. I don't understand that charge.
I'm sorry, 2025.
2025 makes more sense.
Do you understand that charge?
I do.
All right. And Ms. Talene, would you waive a factual basis for that charge?
Yes, Your Honor.
How do you plead then to that charge of trespass at 29th and Canyon on June 9th of 2025? Mr. Kerrigan?
Yeah, I plead guilty.
Well,
Or
accept that
something.
guilty plea. All right, thank
I
you for
did
that.
it.
Any comment before I impose sentence on that charge, Ms. Talene? Or Mr. Altenberg, let's go first with the prosecutor.
Yeah.
No, Your Honor.
Ms. Talene.
No, Your Honor.
All right, same thing I'm going to do on that one. Follow the agreement that's been reached by the parties. 10 days of jail will be imposed. 4 days will be suspended on the condition that the defendant not go back to 1711 29th Street or 29th and Canyon, which is the 29th Street Mall. I will give credit for time the defendant's been in custody and waive court costs. Any questions from anyone?
Not for me.
All right, that should take care of everything. And I believe that's all the cases that we have on our docket.
Yep.
And just for your purposes, Ms. Talene, I'll just say real briefly, I'm going to have a follow-up conversation with Devon and Jose about this policy that they've adopted regarding continuing to have conversations with defendants after their cases are closed. There are these unintended consequences like this one that you've just raised for us that
Yeah, okay, Con, we don't care. I think that's the perfect place to end today's Cavalcade of Stupid. Thank you, Alyssa. That's entirely our fault. We had a problem. We had a false start to begin the stream. We had to start over. Then we lost a clip midstream, but you know, that's okay. That's okay. We soldiered on. We soldiered on through 2 solid hours of complete stupidity. I enjoyed it. Thank you so much for coming out. I really appreciate it. I'll see y'all soon.